everybody take a seat, please? I want you to understand.
Court's in session, please be seated.
Docket number 2014-10417, the Commonwealth versus Aaron Ernandez. May the warrant be recalled, Mr. Magistrate.
Yes, sir.
Has the order of notice been read, Madam Sheriff?
Read 3 times.
May I proceed with the arraignment?
Yes.
Aaron Ernandez, please rise. On May 15, the year 2014, the grand jury in the County of Suffolk returned indictment number 2014-10417-001, charging murder in the first degree. Commonwealth of Massachusets, Suffolk SS, at the Superior Court Department of the Trial Court for Criminal Business, begun and holden at the City of Boston, within and for the County of Suffolk, on the first Monday of May, in the year of our Lord 2014. The jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, did assault and beat Daniel D. Abreu with intent to murder him, and by such assault and beating did kill and murder Daniel D. Abreu. How do you plead this indictment? Are you guilty or not guilty?
Not guilty.
Offense 2, charging murder in the first degree. The jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, did assault and beat Safiro Furtado with intent to murder him, and by such assault and beating did kill and murder Safiro Furtado. How do you plead to this indictment?
Not guilty.
As to offense 3, charging assault with intent to murder armed, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 4, charging assault with intent to murder armed, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 5, charging assault with intent to murder armed, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 6, charging assault and battery by means of a dangerous weapon, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
And as to offense 7, charging possession of a firearm, not at home or work, no license, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
All right, counsel, could we kindly identify yourselves for the record, please, just so we have everybody's name on the record for counsel?
Charles Rankin for Mr. Hernandez. May his handcuffs be removed, Your Honor?
Not presently. The sheriff has asked that they remain.
James Sultan for Aaron Hernandez.
Michael Fee for Aaron Hernandez.
Good afternoon, Mr. Magistrate. Patrick Hagan for the Commonwealth.
All right, thank you.
Good afternoon, Teresa Anderson on behalf of the Commonwealth.
All right, Mr. Hagan, on behalf of the Commonwealth, does the Commonwealth wish to say anything at this
Yes,
time?
Mr. Magistrate. The Commonwealth is requesting that the defendant, Aaron Hernandez, be held without bail. The indictments before this court arise out of a comprehensive, multi-month grand jury investigation by the Suffolk County District Attorney's Office and the Boston Police Homicide Unit. This investigation yielded significant evidence, including video surveillance analysis, cell site location information and records, forensic testing, eyewitness identifications, and witness statements and testimony. This evidence established that on July 16th, the year 2012, at approximately 2:30 a.m., the defendant, Aaron Hernandez, armed with a .38 caliber revolver, shot and killed 2 men and injured a third as the victims were stopped at the intersection of Shawmut Avenue and Herald Street in the city of Boston. The driver of the victim's vehicle, 29-year-old Daniel D'Abreu, suffered fatal gunshot wounds to the chest. The front seat passenger, 28-year-old Safira Furtado, suffered fatal gunshot wounds to the head. 2 backseat passengers escaped without injury, and a third backseat passenger suffered a non-life-threatening wound to his arm. The sequence of events began the previous night, Mr. Magistrate, on Sunday, July 15th, the year 2012, at approximately 10 p.m., when a defendant and a second person left Manchester, Connecticut, with plans to go to the Cure Lounge, a nightclub in Boston. The second person is a friend and associate of the defendant known to the Commonwealth. The pair traveled in a 2006 silver Toyota 4Runner SUV, a vehicle that had been provided to the defendant as part of a promotional arrangement with a Rhode Island car dealership. The SUV was owned by and registered to the dealership and not to the defendant. Just prior to leaving Connecticut, the defendant was observed to place a revolver into the engine block of the SUV where it was hidden but easily accessible. Evidence suggests that in the months leading up to July 2012, the defendant had become increasingly sensitive and angered by what he believed to be people testing, trying, or otherwise disrespecting him when he frequented nightclubs in the area. At approximately 12 a.m. on July 16, 2012, the defendant and his friend arrived in Boston and parked in a garage at 274 Tremont Street, a short distance from the Cure Lounge. By coincidence, Daniel D'Abreu, Safira Furtado, and 3 of their friends arrived at the same parking garage within 5 minutes of the defendant. The victims had traveled to the Theater District from Dorchester in a gray 2003 BMW owned by Mr. D'Abreu's sister. They had previously socialized together at a family Dorchester cookout. None of the victims had been to Cure prior to that night. At approximately 12:30 a.m., the victims entered the foyer area of the Cure Lounge. As they showed identification and paid a cover charge, the defendant and his friend were escorted into the nightclub by a Cure employee. Witness testimony, corroborated by surveillance video from the entrance to the nightclub, indicates that there was no interaction at this time between the defendant and his friend or any of the victims. There is also no evidence that the victims and the defendant knew one another or had ever crossed paths prior to that night. In fact, none of the victims recognized the defendant as someone they had seen before, either in person or otherwise. The defendant and his friend proceeded downstairs, purchased drinks, and stood at the edge of the dance floor. Shortly thereafter, Daniel D'Abreu, while dancing nearby, accidentally bumped into the defendant, causing the defendant's drink to partially spill. The defendant became angered and increasingly agitated, particularly after Mr. D'Abreu smiled and did not apologize. There was no observed verbal argument between the defendant and Mr. D'Abreu, and there was no physical contact between them beyond that initial bump. In fact, neither the victims nor the security staff at the club were even aware that the defendant had become angered or agitated as a result of the incident. The defendant told his friend that Mr. D'Abreu had deliberately bumped him and was, quote, trying him. The defendant's friend quickly convinced the defendant to leave the nightclub and walked him outside just 10 minutes after their arrival. The defendant was captured on surveillance video, quickly consuming 2 mixed drinks as he walked out of the front door of Cure Lounge. For the next 5 minutes, the defendant's friend attempted to calm the defendant as they paced back and forth on the sidewalk leading towards the parking garage. Video surveillance from the outside of the nightclub captured this interaction. The defendant and his friend then walked across the street and entered another nearby nightclub. Within 15 minutes of their arrival at the second nightclub, the defendant pointed out a small group of men now entering that club. The defendant told his friend that this group included the man who had bumped him and spilled his drink. The defendant again voiced his belief that he was being targeted and disrespected by this individual and his friends, and that he believed they were now following him from Cure. Witness testimony and video surveillance revealed, however, that the defendant's belief was mistaken, as the victims never left the Cure Lounge until after 2 a.m. Shortly after these observations, the defendant and the person he was with at the second nightclub left and walked back to the parking garage. Those 2 men were captured on video surveillance from the parking garage, leaving in the same silver SUV. They drove around the immediate area, and at some point the evidence suggests that they pulled over on a street nearby. There, the defendant opened the hood of the SUV and retrieved the loaded .38 caliber revolver that he had placed there earlier that night. At approximately 2:10 a.m., the 5 victims left Cure Lounge. At 2:17 a.m., Daniel D'Abreu and Safira Furtado and one of the surviving victims walked down Tremont Street to get to the car. At this time, the defendant's SUV was captured on surveillance video driving by and slowing down as it passed the 3 victims entering the parking garage. The SUV looped around the block and 3 minutes later slowly drove by again as the 2 other victims now waited in front of the parking garage for their friends to exit in the BMW. Following the second pass, the defendant's SUV pulled over and parked a short distance away. The defendant and his friend walked towards the parking garage and stood near the exit. At approximately 2:26 a.m., surveillance video shows the victim, Mr. D'Abreu and Mr. Furtado, and the third victim exiting the garage in the BMW and picking up their 2 friends. As the BMW pulled out of the garage, the defendant and his associate got back into the SUV. The victim's car passed by and the defendant stated, "There they go." The defendant's SUV then followed the victim's car down Tremont Street. The defendant's SUV briefly stopped at a red traffic light and then quickly accelerated through the red light to catch up to the victim's car. The victim's car was stopped at the next traffic light at the intersection of Harold Street and Shawmut Avenue. At this time, the victims were completely unaware that there was any problem with the defendant or anyone else, and were similarly unaware that they were now being followed. The defendant's SUV pulled up close alongside the passenger side of the victim's car. The defendant leaned out of the driver's side window of the SUV with a loaded revolver in his hand extended out and stated, "Yo, what's up now?" and then a racial slur. The defendant immediately fired at least 5 rounds from a .38 caliber revolver into the victim's car. Witnesses reported hearing the clicking noise as the defendant continued to pull the trigger of the gun after all of the loaded bullets had been fired. Daniel D'Abreu suffered fatal gunshot wounds to his chest. Safiro Furtado suffered fatal gunshot wounds to his head. Both D'Abreu and Furtado were pronounced dead at the scene. The middle backseat passenger suffered a non-life-threatening injury to his arm. Immediately after the shooting, the defendant and his associate fled the scene in the SUV. While traveling westbound on the Massachusetts Turnpike towards Connecticut, the defendant stated to his friend, quote, "I think I got one in the head and one in the chest," end quote. The pair arrived at an address in Hartford, Connecticut at approximately 5 a.m. on July 16, 2012. Later that morning, the defendant searched the Internet and watched television news for media accounts of the Boston shooting. Also that morning, the defendant contacted his cousin, Tanya Singleton, to come from her home in Bristol, Connecticut to the Hartford address. Singleton arrived and left a short time later, now driving the defendant's SUV and leaving behind another vehicle for the defendant to use. The defendant left the Hartford address later that morning in the car provided by Singleton. Thereafter, the evidence suggests that the defendant's SUV that was used in the murder was secreted in a garage at 114 Lake Avenue in Bristol, Connecticut, the home of his cousin, Tanya Singleton. On July 17, 2012, the day after the homicides, the defendant rented a new car from a rental agency. Over the next several months, despite repeated calls and efforts from the Rhode Island car dealership to have the promotional SUV brought in for scheduled servicing and to even be replaced with a newer vehicle, the defendant ignored those requests. In the fall of 2012, the defendant expressed his interest in purchasing that SUV. When he initiated that offer with the dealership, the evidence suggests that he had not driven the SUV in months. The SUV was eventually found on June 26, 2013, in the garage at Singleton's home at 114 Lake Avenue in Bristol, Connecticut, by law enforcement officials investigating the June 16, 2013 homicide of Odin Lloyd. Evidence suggests that the defendant regularly visited his family at that Lake Ave address both before and after the homicides. When recovered by Boston police from the Singleton garage, the SUV was covered in cobwebs, had a dead battery, and did not appear to have been driven in a significant period of time. The interior of the SUV showed evidence that had been thoroughly cleaned, including visible streaks from cleaning solvent on the windows. Subsequent analysis of cellular telephone records for the phone used by the defendant on July 16, 2012, obtained by search warrant, corroborate witness statements placing the defendant at the scene of the murders, traveling to Connecticut afterward, and at other areas at relevant times. On June 21, 2013, Massachusetts State Police recovered a .38 caliber Smith & Wesson revolver during an inventory search of a motor vehicle following a collision on Route 91 in Longmeadow. Forensic testing of the firearm revealed to a reasonable degree of ballistic certainty that this weapon is in fact the murder weapon used to kill Daniel Abreu and Safira Furtado. The operator of that car in which the murder weapon was found is from Bristol, Connecticut, and has connections to the defendant, Aaron Hernandez, through other individuals. Mr. Magistrate, those are essentially the allegations.
All right, thank you, sir. Any issue of bail?
Your Honor, I want to make a statement in response to Mr.
Yes, you may, Mr.
Thank you,
Rankin.
Your Honor. I object to the court giving the Commonwealth an opportunity to make a speech describing what they claim is the evidence elicited by the grand jury to play to the assembled media. The district attorney's press release invited the media to come here today to hear more facts and circumstances about the case, even though there is no reason at all to have a speech by the district attorney's office about what they say the facts are. And the court has just played along with that. This is not supposed to be a spectacle. It's not supposed to be a sporting contest. The defendant has been subjected to an avalanche of publicity, none of which we're responsible for. We've been subjected to wild and extravagant stories, which have been reported as if they're true based on unnamed law enforcement sources. It got so bad that the judge assigned to the Bristol County case has entered a gag order in order to try to assure a fair trial for Mr. Hernandez. We're assembled here in the largest courtroom in this building for a proceeding that should take 2 minutes, but which is not in the confines of the courtroom that you usually sit in, so that this poisoning of the jury pool can continue. It's not fair. Whether the defendant is a football player or a poor person arraigned in the 7th floor clerk magistrate session, he's entitled to the court's assistance in securing him a fair trial. So I object to the court giving the district attorney's office an opportunity to present its one-sided view of the case after a one-sided grand jury proceeding, and to call it fair because I can stand up without having had an opportunity to look at the box of 50 DVDs that we're told we're getting, go ahead and comment on the case. That's not fair. The Commonwealth summary serves no other purpose than to prejudice the potential jury pool. It doesn't serve any purpose for the functioning of the judicial system, and the courtroom should not be used as a vehicle for this purpose. 62 years ago, Justice Frankfurter said that for the prosecutor to feed the news media would be to turn the courtroom into a trial by newspaper rather than a trial by jury. For us, Aaron's lawyers, for Aaron Hernandez, for his friends and family, I say come back when we have a jury, after we have a jury, when you can see witnesses, you can see cross-examination, you can see evidence, and then listen to the case. That's all we ask for. We don't ask to be treated differently. Just give us a fair trial, not one tainted by unfair, one-sided, unnecessary, prejudicial publicity. Thank you.
All right, thank you, Mr. Rankin. I've given you an opportunity to speak, and I'm not going to address all the issues that you raised. I will note that this arraignment started approximately at 1 minute past 2, and now, if my eyes are correct, it's about 16 minutes past 2. So this has been a very quick proceeding. I will also state for the record that I've conducted over 1,900 arraignments in capital cases in Suffolk County since 1983. And in each occasion, the prosecutor has been afforded an opportunity to speak, to address the court relative to the facts of the case. To do otherwise would be violative of custom and procedure that dates back quite a few years, long before my tenure in this court. And I was not going to preclude the Commonwealth from telling the court about the case that they present today. And I've afforded counsel an opportunity to speak. I could not envision a proceeding where the press would not be invited to attend. We do not operate behind closed doors in our system of justice in the United States, let alone in the Commonwealth of Massachusets. So this is an open proceeding. The press, as always, is welcome. I do not control the attendance in this courtroom. You are correct, Mr. Rankin, that I usually conduct these proceedings on the 7th floor in the magistrate session. The proceedings usually take about the same amount of time. We run anywhere from 15 minutes to 45 minutes on an arraignment, depending upon the presentation made by the parties. And there's absolutely, positively no issue of bail. The defendant is a detainee, and the Bristol County has a hold on him without bail. The Suffolk County District Attorney is asking that he be held without bail. Of course, I'm going to hold him without bail. The next scheduled court date will be before Justice Locke, the regional justice in this county. It'll be in this particular courtroom, which is his courtroom, and it'll be on the 24th of June, and that date is by the agreement of parties. Relative to the statements of the Commonwealth has presented what they wish to present in court. They're well aware of their professional obligations under the Code of Professional Responsibility. And I find that the Commonwealth's presentation in the normal course of this case is a usual presentation that I've heard at least 1,900 times before. Thank you very much. Go ahead, Mr. Fiore. June 24th, before Justice Locke, a scheduling hearing. He's to be held without bail. Do you want your client present that day?
Please.
All right, your client will be present.
Aaron Ernandez, the court at this time is ordering you to be held in a minimus without bail, without prejudice. You'll be transported on June 24th, 2014, in this courtroom for scheduling by agreement.
All right, thank you very much. This session's concluded.
Thank you, Mr. Minister.
All rise.
Court stands in recess.
Tom, there. Client's already marked up.
Yeah.